representing some folks from the town of Western. And if it's okay with you to have you to record that for the folks that can't make it today, it's up to you.
You can record.
Okay.
Sure.
Perfect.
Okay. Is this on?
No idea. I didn't go that far.
There we go. Good afternoon. Welcome to session 4F, the Open Meetings Law, an overview and update. Our speaker today is Christen O'Neill. Just a couple of housekeeping items. If you have your cell phones, please silence them. If you do have to take a call, please exit the room, just common courtesy. Christen will take questions during her presentation, so if you have some questions, feel free to ask. At the end, I will be handing out certificates for the end of the day and collecting your lanyards. I'll be at the back door. Other than that, it's Christen.
Thank you. I'm gonna just move this down to the floor maybe, because I'm deathly afraid that it's going to, well, deathly afraid is probably a slight exaggeration, but let's see. Let's do that. Let's do that. That seems to work better maybe. All right. Let me make sure my phone's off. Oops, sorry, I just called my daughter by accident.
Did she have a good day?
She's in college. Oh, all right, she doesn't need me. She's in DC right now, and it's a little bit testy in DC right now. So she tried to call me in the middle of the night, which she knows, I am out to the world in the middle of the night. I am not, so unless, if she, we have Apple products, and so if she uses that Find My Phone feature, I told her if that's what to do in the middle of the night, if it's an emergency, that's what you need to do. But she just called me and kept calling me, and I'm wake up in the middle of the night to 5 missed calls. I'm oh my God, what's wrong? What's wrong? She's nothing, I just want to talk. I'm don't do that to your mother. But anyway, it's a little bit unrestful in Washington. Actually, anywhere where there's a big college campus right now, it's unrestful right now, unfortunately. But anyway, putting that aside, hello everyone. Sorry for the delay. I'm Christen O'Neill. I'm with the New York State Committee on Open Government. For those of you that might not be as familiar with us, we are housed within the Department of State, so we're a government agency. This is our contact information for our office. We're a tiny office. We're a staff of 5, which is double what we've had, say, 5 or 6 years ago. This is our telephone number. If you ever have questions about either FOIL or the Open Meetings Law, you can call that phone number. You can go to our website. There's lots of good information on the website. Copies of these slides are on our website. Even if they weren't distributed through Tug Hill, you can go right to opengovernment.ny.gov, go to the section of our website that says, I would like to view training materials and recordings, and you can get copies of these slides. If you're somebody who prefers to email instead of call, you're welcome to email this address. And that way the first attorney that has an opportunity to get back to you, if I'm traveling today and I don't have a chance to get back to you, first attorney that can do so will get back to you as quickly as possible. This is generally what our email looks like. So this is the top part of the website. The good thing to keep in mind is that these little things are drop-down menus. You can go to copies of our text of the Freedom of Information Law, text of the Open Meetings Law. If we're going to have a meeting of the Committee on Open Government, information about that will be there. Anything new and exciting in the world of open government, we try to get that front and center. Oh, sorry, yes. Is it on, and I just need to get closer to it?
Kind of quiet in the back.
Okay. I'll just try to stand closer to it. I have a bad habit of walking, too.
You want to hold that? I think it comes out.
So maybe that's what I'll do.
Don't break it.
All right. Now you've got me nervous, right? So.
Now you tell.
I was doing a program for the village of Mamaroneck Monday night, there we go, that's not too bad. And it was one of those gooseneck, and I wasn't supposed to carry it, I was just supposed to stand still all night and do the program. And of course I kept walking away, and they're stop walking away. Anyway, So this, like I said, it has a lot of good information on it. If any amendments to the statutes, either FOIL or the open meetings law, get passed, we're going to get that information front and center for you. Anyway, just, it's a nice little website too for you to bookmark if you've heard rumors about any changes to the statutes. This is a good place to check to see if those rumors are true. Open meetings law is codified in public officers law, so sometimes you're going to see references for both FOIL and the open meetings law to public officers law. Again, you don't really need to worry about searching too far to find references to the statutes. We always keep an up-to-date version of the statute on our website. As we mentioned at the beginning, please feel free to just throw your hands up in the air as we're going through if you have questions about anything that I'm talking about. So starting back in the beginning, the open meetings law was passed in 1976, and the declared legislative intent stated that it is essential that public business be performed in an open and public manner and that citizens be fully aware of and to be able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So this isn't just about voting. It's not just about the public having access to seeing its elected officials make decisions. It's also about the deliberations. They want you to have the right to watch how the sausage gets made, so to speak. Who is subject to the open meetings law? They're very traditional public bodies. The term that's used by the statute is public body. And then there's very traditional public bodies that we think of that are subject to the open meetings law. And then there's types of public bodies that are somewhat non-traditional that you might not think of right away. So starting from the beginning, you think it's any entity for which a quorum is required in order to conduct public business. Consists of 2 or more members performing a governmental function for the state or for an agency or department of the state or for a public corporation. And a public corporation is defined in general construction law as county, cities, towns, villages, school districts. So what is a public body there? So a state legislature is a public body, county legislatures, county boards of supervisors, city councils, town boards, village boards, school boards, anything of that nature, are those traditional governing bodies are public bodies subject to the open meetings law. In addition, any committee or subcommittee or other similar body consisting of members of the larger public body are also public bodies subject to the open meetings law. So if you have a 15-member county legislature and 5 of those county legislators have been designated to serve on a finance committee, that 5-member finance committee is now a public body subject to the open meetings law. What else is a public body? Any entity created or appointed to perform a necessary function in the decision-making process and also for which a quorum is required, also has to be conducting public business, and also has to consist of 2 or more members. So this underlined language got added on by the legislature in December of 2021, and again tweaked again in February of 2022. And the goal of the legislature was to codify judicial precedent. In my opinion, it just sort of made things a little bit more confusing, but the goal was to bring into the definition those types of public bodies that maybe were created by statute that had been in a gray area before. So I'm going to give you an example of one that came up recently. A couple of years ago, you may all remember, unfortunately, there was the shooting out in Western New York at the Tops. There's the Tops shooting out in Western New York. So subsequent to that tragedy, the governor and the mayor of Buffalo decided through, I believe it was through executive order, but it may have been by statute, but they created a 514 Commission, because that was the date of the event. And they gave this commission the authority, they put aside a pot of money, and they gave this commission the authority to decide how the money was going to be spent in terms of deciding which artist was going to be able to design like a statue or some sort of memorial in honor of the victims of the tragedy. So they got to choose the artist who was going to build the memorial. They got to determine how the money was going to be spent. They were the final decision makers, the people who served on this commission. They weren't just making recommendations. They got to choose how the government spent their money. So it was sort of a unique circumstance. Unfortunately, when this body was created, nobody told them that they were a public body subject to the open meetings law. And I think not through any nefarious purposes, they weren't having their meetings subject to the open meetings law. And the newspapers, the news media got a little bit miffed about this, and they brought it to our attention. They asked, are they a public body? We dug, we looked into it, we looked into the history, how they were created, and our answer was yes, they're public bodies. They should have been holding their meetings in compliance with the open meetings law. So they started doing it. But again, I don't think there was anything nefarious. They weren't doing it with an intent to keep secret, just nobody ever told them that they were supposed to be having their meetings compliance with the open meetings law. As a caveat, the legislature included the language that a necessary function in the decision-making process shall not include the provision of recommendations or guidance which is purely advisory and which does not require further action by the state or agency or department thereof or public corporation. So if the function that the body serves is purely advisory, then that body is probably not a public body subject to the open meetings law. Any questions on that part? Definition of a quorum. Whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly or as a board or similar body, a majority of the whole number of those persons gathered together in the presence of each other through the use of video conferencing shall constitute a quorum. Not less than a majority of that whole number, so not less than a quorum, can perform and exercise that power that's been designated to them. For the purpose of this provision, for the purpose of the term quorum, whole number shall be construed to mean the total number which the body would have if there were no vacancies and were none of the persons or officers disqualified from acting. So going back to that 15-member county legislature, a quorum is always going to be 8, regardless of how many people are currently serving on that body. Even if you have vacancies, if you have less than a full number of people showing up to a particular meeting, it doesn't matter. Quorum is always going to be 8. You always need to have to have 8 people voting in favor of a particular. First of all, you always need to have 8 people show up to even have a meeting in the first place. And if you need to pass anything, you're going to always need to have 8 people voting in favor in order for that motion to pass. So just sort of out of curiosity, by a show of hands, how many of your municipalities, boards, whatever the case may be, have either passed by resolution or by local law a provision that allows them to use extraordinary circumstances video conferencing? Well, that is a very small amount. I see 1 hand, oh, maybe 2 hands. That's a very small amount. Okay. So 2 years ago, as I think at this point, the states of emergency were still in effect relating to COVID. The states of the executive orders had ceased relating to the suspension of the in-person requirement for the open meetings law, but there is still some temporary legislation in place. So during the 2022-23 budget season, the legislature passed and Governor Hochul signed Chapter 56 of the laws of 2022, an amendment to the open meetings law that expands the use of video conferencing by public bodies to conduct open meetings law, but only under extraordinary circumstances. So this provision was just extended. It was set to expire on July 1st, 2024, but just this 2 weeks ago, when I think it was on, yeah, it's in there. I think, oh, I guess I didn't put the date in there, but on April 20th, when the budget was passed, the provision was extended through July 1st of 2026. So if you do have a local law or a resolution in place that allows you to have extraordinary circumstances video conferencing, you can continue to have that in place through 2026. The provision is not meant to change or curtail what you were allowed to do pre-COVID. If you were allowed to do it pre-COVID, you can continue to do it. There were provisions in place that allowed you to use video conferencing before COVID, but if you were going to use video conferencing prior to COVID, all of the locations from which you were video conferencing had to be open to the public. So there are two ways to use video conferencing. One is where you're connecting multiple physical locations that were open to in-person public attendance, and two, where you're allowing a member of a public body to participate from a private location through video conferencing, but only under extraordinary circumstances. If you're using the old pre-COVID way, all the new provisions that were created through the amendment to the open meetings law under Section 103A do not apply. There's a lot of rules that go in that have to be followed if you're going to take advantage of the extraordinary circumstances video conferencing. One is that you need to keep in mind that only the individuals that are present at a location that is open to the public count towards a quorum, unless the person is suffering from a disability that prevents them from attending in person. So if you're participating from a physical location that's been properly noticed and is open to in-person public attendance, you do count towards a quorum and can fully participate and vote. If you're video conferencing from a remote location that's not open to in-person public attendance, you do not count towards a quorum unless that person meets the disability criteria. And the disability criteria is that the disability prevents you from attending in person. However, once the quorum requirement's been met, all the members can then fully participate and vote. In order to take advantage of this provision, the governing board of a county, city, town, or village must adopt a local law. The state, the Senate, and the Assembly had to adopt a joint resolution, and all other public bodies had to adopt a resolution. You can either do, like, a governing body could adopt it just for itself, or it could adopt it for both itself and all of its committees and subcommittees. It could also adopt it for itself and all of the public bodies that's housed within its municipality, for example. Have to establish written procedures governing member and public attendance consistent with the open meetings law, and those procedures have to be conspicuously posted on the website. So when we're talking about the extraordinary circumstances, what do we mean? So first, I'll point out that the legislature here is showing a clear preference for in-person attendance. The law says that members must be physically present at the meeting unless the member is unable to be physically present due to extraordinary circumstances as set forth in the resolution and written procedures, including disability, illness, caregiving responsibilities, or any other significant or unexpected factor or event which precludes the member's physical attendance at the meeting. The legislature is showing a clear preference for in-person meetings. Except in the case of executive session, the public body shall ensure that members of the public body can be heard, seen, and identified. During COVID, if we were doing a remote meeting, you didn't have to turn your camera on. If you're attending remotely now, you do have to have your camera on. And also when you log on, you have to make sure you type your name in, full name. The minutes of the meeting have to indicate which, if any, members participated remotely, and then of course have to be available just like any other minutes of a meeting subject to the open meetings law. The public notice for the meeting has to inform the public that video conferencing will be used, where the public can view or participate in the meeting, where required documents and records will be posted, and must identify the physical location or locations for the meeting where the public can attend in person. Public body shall provide that each meeting conducted using this type of video conferencing shall be recorded, and such recording must be posted or linked on the public website of the public body within 5 business days following the meeting, and shall remain so available for a minimum of 5 years thereafter. The recording shall be transcribed upon request. If it's used to conduct a meeting, the public body shall provide the opportunity for members of the public to view the meeting via video. So if you allow your members to attend via video conferencing, you have to allow the public to attend via video conferencing. You also have to allow the members to participate in proceedings via video conferencing in real time where public comment or participation is authorized, and shall ensure that video conferencing authorizes the same public participation or testimony as in-person participation or testimony. If you have a meeting that doesn't allow for public comment for people that show up in person, then you don't have to allow the people that are attending virtually to have public comment. But once you allow for public comment for the people that show up in person, you have to allow for public comment for the people that are attending remotely. Because there are posting requirements, website posting requirements, the law requires that if you want to use this provision, you have to have a website. The law also states that if there's a statewide disaster emergency or a local state of emergency that would affect or impair the ability of a public body to hold an in-person meeting, the in-person requirements of the open meetings law can be suspended. So that sort of is the overview of that, of the extraordinary circumstances video conferencing provision. Go ahead.
If a council member goes on vacation and joins a meeting, they can't vote, right? Can that council member, if they decide to, go into executive session with the board via video conferencing? Is there a quorum? Well, if there's a quorum, then that's, let's say somebody goes on vacation in Florida and they're on the town board, they want to join in the meeting, so they join in video, or, can they go into executive session with the rest of the board?
Here's what they should do, is they should notice their location. Because if they notice their location, even if in practice, no one's going to actually show up to that location, because if they notice their location, so if the meeting, they're on vacation, they're Florida, wherever they are, they're on vacation, the notice of the meeting states that the meeting, members of the town board will be attending from Town Hall and also 123 Sesame Street, Boca Raton, Florida. And then the public is welcome to attend at any of those locations.
Right.
At that point, all of those board members are allowed to count towards a quorum, are allowed to vote. That board member in Florida is treated just like any other member of the board. Can go into video, can vote in open session, can participate and vote in executive session.
Even though it's not an extreme circumstance, it's just...
It's like the old way of video conferencing as opposed to the new way of video conferencing. If they're not willing to notice their location, they really just can't, they can't do it at all.
Okay.
They can't even really, they shouldn't even be logging on to video conference.
Okay.
They shouldn't be participating in the conversation. They can watch just like any other member of the public, but they shouldn't be participating in the conversation.
Thank you.
So do people, not members of the board or attendees of the meeting, have to be able to see the person that's in the remote location?
Yes, they should be able to see the public should be able to see the person who's attending remotely. Yes. All right, notice. Notice of all meetings must include the date, time, and location, and if appropriate, because of extraordinary circumstances, instructions for virtual attendance. This must be given prior to every meeting to the media. You don't need to purchase a legal notice under the open meetings law. Hearing notices are different, and that's under different statutes, but for the open meetings law, you just have to give the notice to the media. Must be placed in a designated physical location, like a bulletin board or something like that. And if your agency or public body has an active website, must be posted on that website.
Okay, leave that up for just a second.
Okay.
We're off the special circumstances and video right now.
Yeah, we're done with that entirely. We're back to just sort of normal open meetings law.
We don't need to purchase a legal notice.
No.
It can be posted in the town. It can be given to our local radio station for announcement. Whatever the requirement is, I think it's 3 days before a public hearing.
Timing is on the next slide, but go ahead. We're not talking about hearings, we're talking about meetings. Hearings and meetings are two different things.
Okay.
In terms of timing, notice must be given at least 72 hours prior to a meeting that has been scheduled at least 1 week in advance. You can do it all at once at the beginning of your calendar, fiscal year, whatever the case may be, if that's your preference. Like, for example, at January, if you just want to establish a single meeting schedule and post that at the beginning of the year, send that out to the media at the beginning of the year, that's fine. Or you can do it once a week or whatever the case may be, as long as it's at least 72 hours prior to any meeting that's scheduled at least 1 week in advance. For all other meetings, meaning meetings that are not scheduled at least 1 week in advance, notice must be given to the extent practicable at a reasonable time prior to the meeting. The open meetings law itself is silent as to when you are allowed to have meetings less than 1 week and schedule a meeting less than 1 week in advance and provide less than 72 hours notice, but the courts have not remained silent on this issue. The courts have stated that the propriety of scheduling a meeting at less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. Would some type of harm be caused by waiting? There's certainly circumstances in which some type of harm would be caused by waiting, and you need to get your board together to make a decision. And that's fine. That's why we have this provision in there in the open meetings law. But if no harm would be caused, then you should not be having meetings like, hey, let's try to slide this through without the public noticing we're doing it. That's not a good reason to have a meeting, to decide in the morning to have a meeting in the afternoon. Not that anyone in this room would do that. I'm just pointing out that that's not a good reason to do it. If extraordinary circumstances, video conferencing is used, the notice has to include a statement to that effect. Records scheduled to be discussed. In October of 2021, Governor Hochul signed into law Chapter 481 of the laws of 2021, which amended Section 103E of the Open Meetings Law to require that records scheduled to be discussed during an open meeting must be made available to the extent practicable upon request and posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. The obligation to make these records available to the public upon request used to be prior to or at the meeting, and to post the records on the agency or public body website prior to the meeting. And that had been in effect since February of 2012. This amendment that took place in 2021 simply placed a 24-hour minimum time frame for making those records available. But I have to say, most people were not aware of this. There were so many people that only first became aware of this requirement in 2021. Somehow it slid under the radar. These are the types of records that we're talking about. All proposed resolutions, laws, rules, regulations, policies, or any amendment to any of those things, all of those things in the first bullet are required to be made available at least 24 hours prior to the meeting. In addition, any record that would be available under the Freedom of Information Law or record or portions of records. Maybe there are things that could be redacted from a record, but the remainder would be available under FOIL. If that's the case, you can redact, but post the remainder or disclose the remainder, and that record should be available to the public so that they can follow along with the board as they discuss the content of the record. That's the goal of this provision, so that as the board discusses the record, the public can follow along and see what the board is talking about. The law says that the agency may, but is not required to spend additional money to implement this section, and it does not apply to records discussed in executive session. Minutes must include a record or summary of all motions, proposals, resolutions, or any matter formally voted upon and the votes thereon. If extraordinary circumstances, video conferencing is used, must include which, if any, members participated remotely. For executive session, you only need to prepare minutes of an executive session if you vote or if actions are taken in executive session. If a public body merely deliberates in executive session but then doesn't vote or comes out and votes in open session, then no separate minutes of the executive session need to be prepared. Those minutes must be prepared and made available to the public within 2 weeks of open session and 1 week of an executive session, and it does not matter whether those minutes are unapproved or in draft form. Yep.
So with respect to things like supervisors' reports or highway department reports on a standard meeting, are those required to be out there 24 hours in advance or not?
Records scheduled to be discussed.
Okay. So
That's all I can say. I mean, I don't know.
No, that's fine.
I just keep repeating that to people. You know, do you plan to discuss the record? You know, does the board plan to discuss the record? If the answer is yes,
Then it needs to be there.
then it should be available to the public at least 24 hours to the extent practicable.
Perfect, thank you.
The fall of 2021 was a hotbed of activity for the open meetings law. I think this is the third amendment that we've discussed. November of 21, Governor Hochul signed Chapter 587, which amends the open meetings law to require agencies that maintain a website and use a high-speed internet connection to post their meeting minutes on their website within 2 weeks of the date of the meeting or within 1 week of an executive session. The law states that for purposes of this subdivision, and that language is important, an unabridged video or audio recording or an unabridged written transcript may be deemed to be meeting minutes. All that means is if you would prefer to post online an unabridged audio or video recording or unabridged written transcript in lieu of posting meeting minutes, you can do that, but this does not relieve you of your obligation to prepare meeting minutes. That's all that means. You still need to prepare meeting minutes, and you still need to do it within 2 weeks. It's just, there are certain public bodies that don't meet very frequently, and there's a hesitation about posting unapproved meeting minutes. So some people would prefer to perhaps post an unabridged video recording instead of posting an unapproved meeting minutes. Yes, sir.
So if you're a review board and you want to record the sessions, right? There are multiple sessions. You're obviously going to start and stop recording for each session, right? Is that still considered unabridged even though there's multiple recordings?
I'm not really familiar with how it works. I don't know what you mean.
You don't know what I mean. So let's say the Board of Assessment review, right? Mm-hmm. So you have a Board of Assessment, that board sits for 4 hours, right? There may or may not be activity, right? So if an agreed party comes in, right, then you'd want to record that session for the minutes, right?
I would say
if that person leaves, right, and now you're sitting there for another 2 hours with no activity, right? Sheriff's not going to record the silence.
Yeah, I mean, I would imagine as long as you're recording all activity that involves.
So you're doing like multiple sessions.
Yes, I see what you mean. It's just unusual. It's not like a normal meeting, but yes.
Gotcha.
I got you, yeah. That's all right.
So that would be considered unabridged, even though it's multiple recordings of the same meeting. See what I mean?
I don't see why not.
Right.
Yes, it's just an unusual circumstance, but I don't see why not. But the other option is just to have somebody prepare minutes and get them up within 2 weeks.
It's getting harder and harder to find folks who do that.
Yes.
So is the Board of Assessment Review something that is required to be recorded? Because that's not a quorum type of a,
Board of Assessment Review is a public body.
okay.
Well, you have to quorum, you don't have to legally record it, correct? You can use minutes.
Minutes.
These are the minutes, I think you were just
This
asking
is right,
if you would
record it.
prefer to record it, you
Right.
could. That's all I meant, I assume that was your question, that was if you wanted to do that in lieu of preparing. Well, you can't, you still have to prepare minutes, though, but, and you still have to do it within 2 weeks, it's just you.
So the
Post it.
recording can't
Replace meeting
replace
minutes.
the written minutes.
Correct. So it really doesn't help. The only thing it helps is that you could post the recording instead of posting unapproved minutes, which some people have a problem with.
Does the recording, so become part of the official record, or the written, is the written transcription of the recording the official record?
Those words mean nothing to me,
Oh, okay, all right.
honestly. Like,
Check with your local attorney.
well, honestly, as a FOIL person, the word official record means nothing to me. Like, a record is a record. Once you create information in any physical form whatsoever, it's a record.
Okay.
An official record means nothing
And
to
so
me.
it needs to be kept, the recording.
What you want to do is check with your record retention schedule under the LGS 1 to see how long that needs to be maintained.
Well, what's the very last sentence mean?
Nothing in this section shall require the creation of minutes if the public body would not otherwise take them. Perhaps it has to do with A, executive session, or B, if you have something like a work session where you don't vote on anything. Perhaps.
I was a custodian of this recording, and you normally wouldn't do minutes. A recording would suffice for the minutes.
No, I think it means situations like a work session where you would not otherwise, where you wouldn't vote, or in general you don't vote on. Sometimes you might vote on something, but
That makes sense.
Minutes, post in a draft bill within the time, when is it required to post the tweet?
under the open meetings law, there's no distinction between approved. There's nothing in the law that requires minutes be approved.
So-
It's just a practice, a standard practice, and there's nothing wrong with having that as a standard practice. It's just, my recommendation is that if it is your practice, just post them as drafted. Once they are approved, you can just replace the draft version with the approved version. Even if that's, honestly, for example, I'll use us, the Committee on Open Government last met in December. We won't meet again probably until September or October, because we meet like 3 or 4 times a year in the fall. So those draft minutes that we posted in December won't get approved until like September. And so that's fine.
So it can remain until such time as they're approved,
Yes, sir.
and then reposting. Okay,
Yeah.
but the key is you're required to post something.
Yes, sir. Exactly. You got it. In terms of recording, any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and/or transmitted by audio or video means. Agency is not obligated to record unless a member is participating remotely as authorized under Section 103A. An agency may establish reasonable rules to limit disruption or interference, and we have model rules available on our website. Executive session is defined in Section 102.3 of the law as a portion of an open meeting that is not open to the public. An executive session should never be prior to or separate from an open meeting. A motion must be made during an open meeting, so you must first, even if you know that your executive session is going to take up 99% of your meeting, you must first notice an open meeting, enter into an open meeting, make a motion to enter into executive session, vote upon that motion, and then if it passes, then you get to go in. The motion must be specific. It must be contains, so here's all the reasons that you're allowed to go into executive session. If you don't see it on this list, you're not allowed to go into executive session. What I want you to keep in mind is that the court has spent a lot of time thinking about what you are and are not allowed to say when you're making motions to go into executive session. They have spent a lot of time talking about this issue. So you want to be thoughtful about this. First, you want to be specific enough to reflect to your fellow board members and to the public that you're going in for a proper purpose. 2, do not parrot the language of the statute. I know I'm making it hard for you, but in actuality, it's not as hard as you might think. You just want to, I'm going to fast, well actually, no, we're going to stay right here. The first 3 I hardly ever see. We're going to start with letter D, discussions regarding proposed, pending, or current litigation. I move to enter into executive session to discuss O'Neill versus the City of Albany. That is specific enough to reflect that we're going into executive session for a proper purpose. I am identifying the specific litigation that we want to discuss. That's what you should be doing. That's what the courts want to see. You're identifying, you're discussing the actual litigation that the board wants to discuss behind closed doors. Please keep in mind that the word potential and possible is not there. You cannot make a motion to enter into executive session to discuss a potential litigation. Anything a public body does, anything a board does, any decision that is made has the potential to lead to litigation. You are only allowed to discuss actual or proposed litigation. And when I use the word proposed, I think a good rule of thumb is, has a notice of claim been filed? That's a pretty good rule of thumb. I'm not saying it's the only rule, it's the only situation that fits, but it's a good rule of thumb. So it has to be actual litigation or so close to litigation, it's right on the edge. Collective bargaining negotiations under the Taylor Law can be discussed in litigation. So, for example, you might actually identify the bargaining unit that you're having, whatever collective bargaining negotiation, the bargaining unit that you're having that conversation with. F, we see this all the time. Here's my selling. Don't use that word. I see it all the time. No matter how many training sessions I do, I've had this slide in my training sessions for years and years. I still see it. People still say, I move to go into executive session for personnel matters. This word does not appear anywhere in the open meetings law. It's too broad. It does not reflect to the public that you're going into executive session for a proper purpose. On the other hand, don't just parrot this. This is ridiculous language. I move to go into executive session to discuss the medical, financial, credit, or employment history of a particular person or corporation or matters leading to the appointment, employment, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. That's ridiculous. Nobody has any idea what that means. Just say what you mean. Are you reviewing resumes? Say that. I move to go into executive session to review the employment applications that we received in response to a job posting for blah, 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 blah. Say it. I move to go into executive session to discuss the employment history of a particular person and the possibility of disciplinary action against a particular person. Do you need to identify the person? No, of course not. Just be as specific as you can without defeating the purpose of the executive session. Probably the last one that might come up with any frequency is the letter H. The proposed acquisition, sale, or lease of real property, or proposed acquisition of securities or sale of exchange of securities held by such public body, but only when publicity would substantially affect the value thereof. Again, this is one where it doesn't make a whole lot of sense to say the whole thing. You just might want to indicate we're going into executive session to discuss the possible sale of a piece of property or the possible purchase of a piece of property. And this is probably a situation where you don't necessarily want to identify the property. It just might depend on the circumstances. But here, the main thing is, like, for example, if you're selling property and you've received an offer, you don't want everybody to know if you're willing to accept that offer, like how high you're willing to go, how low you're willing to go, depending on if you're selling or buying. Those are appropriate conversations for executive session. So that was the first avenue for meeting behind closed doors. The second avenue for meeting behind closed doors is an exemption. Section 108 of the Open Meetings Law establishes exemptions. If an exemption applies, the Open Meetings Law does not. It's as if the Open Meetings Law does not exist. The first is judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. Quasi-judicial proceedings usually tend to be, so it's a public body that is holding some type of hearing where they are the final decision maker on behalf of an agency, and the only step after that decision would be to bring an Article 78 proceeding. That's the way we look at, are they conducting a quasi-judicial proceeding? The second exemption is whether that public body or a quorum of a public body is having deliberations of a political committee, conference, and caucus. So for example, if you have a 5-member town board and 3 of them are Democrats and 2 of them are Republicans, those 3 Democrats can meet wherever they want, whenever they want, and talk about whatever they want, and it will not be subject to the requirements of the Open Meetings Law. They can't vote, but they can talk about whatever they want, even though they represent a quorum of the public body. The third bullet is any matter made confidential by federal or state law. And here the most common situation that arises, and where people get a little confused sometimes, is, and they'll reference it, they'll describe it as executive session when in fact it's an exemption, is when they're meeting with their municipal attorney to receive legal advice. And they're having conversation that's covered by the attorney-client privilege. So they'll say that they want to go into executive session to have an attorney-client privilege conversation. It's not executive session, it's an exemption, because it's a conversation that is made confidential pursuant to New York State civil practice law and rules. So if you're meeting with your attorney for the sole purpose of requesting and receiving legal advice, that conversation is made confidential pursuant to New York State statute and is confidential under New York State law and can be exempt under the Open Meetings Law. Yes?
Would that be a separate part of the meeting? In other words, would you go
It can be
into
whatever it wants because it's exempt from the Open
So it
Meetings
could be,
Law.
oh, I see, so it could be within the executive session that happens?
It could be within the executive session, it could be within the Open Meetings Law, they could just say, we're gonna step aside right now to have an exempt conversation. It could be completely outside the scope of the meeting entirely.
But they would have to say that they're doing an exempt.
They don't have to, but it would be a good idea, because otherwise everyone would wonder why they're walking out of the meeting.
Exactly.
Right,
Yes.
yeah.
But, okay, thank you.
So wrapping things up, just as a reminder, the Committee on Open Government does not have enforcement authority. Our role is to provide advice. We are an open resource. Anyone is welcome to call us with questions about the Freedom of Information Law, Open Meetings Law. Enforcement is through the initiation of a Civil Practice Law and Rules Article 78 proceeding. A successful petitioner has the authority to be awarded costs and attorney's fees. If the court finds that actions were taken by a public body at meetings held in violation of the Open Meetings Law, the court can decide to invalidate those actions. If the court finds that the violations were merely technical in nature, the law specifically addresses those situations and says that a court should not invalidate actions based on mere technical violations, so it's going to have to be more substantive violations. And this is my favorite part, is that the court can require that you take training from me if you're found to be in violation of the Open Meetings Law. So if you have questions, I'm happy to take them now, but of course you're also, just as a reminder, please remember that you've got, always contact us, yes.
Can you shed any light on Is there a difference in a public meeting if it's announced as a regular meeting or a work session?
Really, there's nothing in this open meetings law that makes a distinction. It's just sort of intent. It really just reflects the intent of the board.
But still, if the forum was present, if needed to be at a work session, so then the body could vote.
Oh, yeah.
Okay. They could still make decisions.
Yes, they could.
All right.
Yeah.
Yeah, this question, that was great, it kind of relates back to like a committee set up or something like that. So say if the town board wanted to set up a committee to do research, and this committee is going to be staffed by citizens of the town, and maybe 1, 2, or 3 boards on that. They're not going to do any decision making, they're not going to spend any money, they're just going to do research. Say they wanted to research, the town is thinking of building a new town park, and you're going to get maybe ideas, formula ideas to come back to the town board with a plan, and that plan would be open to the public. Now, those meetings, working sessions that they have, no decision will be made. Does that fall under the open meetings law?
You want to keep it to less than a quorum. If you have a 5-member town board, you definitely want to keep it to less than a quorum of the town board. So you don't want to have 3. But if you have 2 town board members and then, like, I'm going to say 3 or more residents, if you have non-town board members outweighing the town board members, the likelihood is the courts would find that to be a purely advisory body in nature. All committees of a public body, whether it's a town board, city council, county legislature, all committees that are made up of just the board members or just the council members, they're mostly just advisory anyway, but it doesn't matter because the law specifically says that any committee that is made up entirely or primarily of members of the full public body are public bodies too. So if you've got 2 town board members, just 2 town board members serving on a committee, it's a public body. If you've got a 9-member city council and 3 of them are serving on the finance committee, they're a public body, and you work your way up. But if you start mingling board members with residents and business owners and students, then when you have those non-board members outweighing the board members and it's purely advisory in nature, then they're not going to be considered public bodies subject to the open meetings law.
In which case, mostly you're going to have it open to the public anyway.
Probably, but sometimes the nice part there that has come up more frequently recently is that if you want to have it virtually, you could, which has been a bigger bonus in the past couple of years that wasn't as much on people's minds in past years.
So what about other work sessions like development of language for laws and comprehensive plans, right? If they delegated that to say planning board or zoning, maybe pull in members of the public to consult, is that a public body? Where they're developing language for
Read it
laws?
down, like who's serving on this?
So it depends who's serving. So if there's a town board member or 2.
Because like for example, there's a comprehensive planning committee that's established under town law and village law. Because those are established under both village law and town law, those are public bodies because they serve a statutory function.
Okay, so those are public bodies just by definition of what they're doing developing the comprehensive plan.
Yeah.
Interesting.
Yeah.
And then, of course, subject to open meeting, speaking units and all that stuff.
Got it. Yeah.
Where can I find information on what is required for public hearing, notification for public hearing?
There is the Division of Local Government Services within the Department of State has a it's called the James Coons, what's it called? I'm not gonna be able to pull it up because I don't have website. Did any of you take training from from local government people today? No, shoot. If you go on, it's a publication put out by the Division of. I'm sorry.
Technical series,
Yeah. What was it called again?
James A. Coon Local Government Technical Series.
Yes, and then it's specifically about public hearings. is a good resource. Yes. Yes.
When a town board goes into executive session, if they list multiple reasons, they can talk about multiple topics. They don't like have to just specifically talk about one, then have another.
No, they can say, okay, these 4 things are the things that we plan to talk about, and then they can go in and talk about all the 4 things. If something comes, and also someone has asked me this before, if something comes up while they're in there that is appropriate for executive session, in my opinion, they can talk about it, but tell everybody when they come out that they talked about it. Just say, oh, by the way, while we were in there, this came up, and we just want to let you know that we also discussed. Just only because it seems kind of silly to come back out and say, hey, we're coming out just to make a motion to go back in, but that's just my personal opinion. I'm not a judge, but yeah, go
So
ahead.
when somebody goes into executive session and you're then doing your minutes after, do you have to set forth that you went into executive session, or you went into executive session to discuss and then set it out? Right?
Yes,
Okay.
whoever's preparing minutes has to include the reasons that the body went in. Yeah. All right, well, thank you for joining me here today. I'm glad I got you out a little bit. I'm going Saturday. I'm driving out Saturday to go get her. I'm kind of happy about that.
I hope you feel better.